be the attorney. Over my 26 years, I'm not sure I've seen one person cause this much damage.
I don't see a legal problem.
My problem is everybody in this courtroom has been hurt by this person.
Your Honor, tenants Erica and Aaron Ward own and operate a horse boarding farm on the property. Under the lease, tenants are required to pay base rent of $5,500 per month without any deduction or set-off whatsoever, and that's paragraph 3 of the lease. Tenants, what really kickstarted this dispute, tenants set off $2,800 from the June 2025 rent when they unilaterally placed the hot water tank on the property in violation of the lease. Tenants have not paid rent since August of 2025. From my knowledge, tenants are supposedly placing the rent in their attorney-client escrow fund. They're paying contractors and for supplies with the rent money owed to landlords. Tenants are operating their commercial horse farm rent-free on the property. During the pendency of their circuit court action, tenants admit to withholding rent, so there's really no factual dispute here. Right now, I believe the base rent owed is $24,800.
Your Honor, I know that you are a very thorough judge, and I filed an answer to plaintiff's complaint to recover possession of the property. In that answer, I listed out the situation that led to our filing a breach of lease complaint in the circuit court. The property has, and it states so in the lease, has been used as a horse farm. It's zoned agricultural for over 25 years. About a year and a half ago, Erica notified the landlord. Several of the outdoor sheds that shelter the horses had deteriorated to the point where they fell down.
But what about the provision that the base rent is going to be paid without deduction?
That is if they live up to all of his responsibilities.
Is it conditional? That's not what I read.
It is not conditional, but in any contract where one party breaches several...
I have two businesses, in essence, that have entered into a contract. That contract can read various different ways. I mean, you're trying to say that there's a general reading for contract. Maybe if it weren't two businesses operating at arm's length, you might be correct, but that's not what I have.
No, we have a lease, and under Michigan landlord-tenant law...
Where is that base rent now?
So, in June, they notified him to please repair the hot water heater. He did not. They repaired it themselves. They withheld the cost of the hot water heater. Aaron did the labor installation himself. They paid him the difference between that withheld for necessary repairs that the landlord is duty-bound to provide under the lease, and gave it to him. He then...
That's June.
That's June.
Okay, what happened in July, and where's that rent?
Yep, they paid it.
August.
We started withholding in August 1st. In July...
So, all right. No, not really.
No.
You
Okay.
ever do that to me again, you'll be out in the hallway.
Thank you. I apologize. I was not trying to.
August, September, October, where is the base rent?
The tenants told the landlord that they were going to have these things repaired, and that they were going to withhold the rent to make the repairs.
Why can't I just get an answer to my question?
And after they notified him, he had threatened to take over the farm, insert his own manager, and they paid the rent into an escrow fund, out of which the necessary repairs were made. They withheld the rent to make the payments to the contractors that were filling the dangerous holes in the pastures.
Where, out of what account?
They paid the account into an escrow fund that I held for them to be able to pay the contractors for the necessary repairs.
Counsel, like the last case you were here on, now we have a problem. I want to know where the escrow is.
The escrow is in my, it's all paid out. The escrow funds are all paid out to the contractors. They paid this month's
Counsel,
rent.
do you see the problem here? Do you?
Well, I know you want me to see the problem, but
Then that must be the answer is no.
no.
You took client money in.
I withheld rent.
And then dispersed it.
I withheld rent under the landlord tenant.
But you can't on your own then disperse it.
They dispersed.
Ms. Tope.
Erica Ward signed those contracts and paid those
Ms.
contracts.
Tope, if as a tenant, they elect to set up an escrow account to put their rent into, show me the authority that then permits them or their agent to disperse those funds.
This was not.
Show me authority for that. Because I'm going to tell you, you're not going to find it. Outside of the fact of the first thing that I said, where you might be in violation, and I'm not saying you are, and I hate even making the accusation, of ethical rules that would apply to attorneys taking clients' money into trust. I
understand.
And again, I will give this blanket statement. I am not saying that making any accusation. I'm not making any finding. I'm not saying any of that. I'm not saying even to a great extent my analysis, if I were to come down to the end of it, is correct. All I'm saying is that's what I see on the surface. But we have another problem here, because not only was that part done, but as I'm to understand then, those funds were then dispersed elsewhere. That creates a whole different ballgame, particularly where you're claiming a breach as to who did it. So while I recognize and understand what you're saying, it's all a mess, and they're sort of a mess on both sides. Less of a mess over here, more of a mess over here. I gotta try to clear that mess before I can even begin to deal with that. I really don't have a dog in that fight. There's no reason for me to say it other than the fact that you're facing jeopardy on a number of different levels. And so I'm going to do this, and I realize that it delays plaintiff, but I think the court is compelled to do this. I'm going to adjourn 1 week to the 21st at 3 p.m. The basis upon which I'm adjourning is, I think, Ms. Tope, you need to get the advice of counsel as to how you should move forward and if you should move forward.
Erica approved all.
Who were signatories to that account?
I was.
There's a problem.
But not my attorney.
Okay, so no. That's our problem. So, who else was a signatory to that account?
No one else. Me alone.
Do you not see a potential problem with that, Ms. Tope? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it, but I don't see a legal problem.
Don't you really yourself become a necessary party to this action? And that's what I'm saying. And if you're a necessary party, Ms. Tope, you can't be the attorney. Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, is not my issue. You understand what I'm getting at?
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing was I did not want a circumstance where, Ms. Tope, you're brought in as a party and then your clients are left without representation. Ms. Tope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track, for sure.
That what?
We are on this case. We are off track. I will prepare withdrawal papers and have them sign it. We talked about this. They're in agreement.
All right. So you're going to withdraw as counsel?
Yes.
All right.
Your Honor, my client would like to say a few words.
That's fine. Yes, go ahead.
Thank you. Thank you. Your Honor, so my background is I'm a family man with 6 children. This property is our family's entire retirement. I was adopted, worked my way through school, started a mortgage company in 2003 that's operated for 22 years without a single bad review. I've served on the board of the directors for the Arthritis Foundation and Entrepreneurs Organization. I work with the Congressional Medal of Honor Society. I spent over 10 years coaching and sponsoring at-risk youth for football and baseball, including future Maryland running back Nolan Ray. We have saved our entire life to be able to purchase this property. The tenants have been operating a business on it without paying rent. They've made false statements about me, potential future buyers. They've contacted my land contract seller to try and usurp me and purchase my debt. The land contract seller contacted me to alert me immediately and denied that.
I will expeditiously get this matter to trial if that's where we have to head. I don't have a problem doing that, but I can't set things when things are in such disarray, quite frankly. The 19th, 2025, 1 p.m.
Your Honor, we're here for our 4th pretrial hearing. If you recall from the last hearing, you adjourned to give plaintiffs time to seek alternative counsel.
Right.
It appears that they used that time to file a dispositive motion and an omnibus motion for repairs and Ms. Tope's motion for withdrawal 2 days before this hearing, which I received a copy at close of business on Wednesday, which forced landlord to file its own MSD, which was filed with the court this morning. So it appears it is further delay by tenants, and it's another month with my client not receiving any rent payment.
I'm going to grant the motion to withdraw. I am not going to sign the order that you have indicated. You will prepare an order that it is effective now.
Okay. We can just write it in?
You can do whatever you want to do. I just need something to sign that indicates that you are
Effective immediately?
immediately.
Yeah. And I'll sit down.
You folks are not in a position to argue anything regarding this right now, are you? I'm also going to direct, at least at this point, that there are to be no other motions filed between now and the time of that hearing.
Their sole defense is that this is a residential lease. I believe the argument is meritless. I don't like throwing this word around, but I believe it's also frivolous. Tenants admit in their filings, this court and the circuit court, that they're operating a commercial horse farm on the property Willow Ward Equestrian. Tenants don't reside on the property, and it's a business collecting money from boarders boarding their horses at the farm.
Are you really arguing that this is not a commercial lease?
Yes, I'll be arguing that it's a residential lease and the tenant, the landlord, the entire time acted in harmony with us in residential lease premises.
The problem is you can't withhold. I mean, I'll let you make your argument. I just don't think it's going to get you anywhere. Who represents you guys in the circuit court matter?
Our attorney, Ms. Tope.
You realize that in these two proceedings, whether the representation is made by you or whether it's been made by your attorney, that you can't make inconsistent representations. You realize you can't do that.
He did not represent us in our other case.
No, that is not here. yet. You can't say one thing in one case and then another thing in another case. And while you guys may not have said it yourselves, but have said it through an attorney, as I'm to understand and what I see, your attorney, Ms. Tope, has made the representation in a circuit court matter that this is a commercial property.
I'm not going to disagree with you.
Okay.
I don't know.
Now,
Not.
pardon?
I don't know if she's made that.
But you, okay, folks, this is where the problem comes in with you not being represented by counsel. Because if you're going to, and I'm going to give you one break, or as many breaks as I think are appropriate, but if you persist in it, there's going to be problems. Because if the representation has been made that it's commercial property there, and then you're left to argue before me that this is a residential lease, that's going to be a problem, a sanctionable problem. Because I almost have to believe that if you're arguing that, you're arguing that in bad faith. You're now before me arguing this case. I won't be sanctioning her. I will be sanctioning you. Because when it comes out of your mouth, you're stuck. There are documents that are being filed in this action, not by you.
Nor with my permission. I don't know how I...
Was there anything recently filed in the Circuit Court Action Council?
No, Your Honor. Yes, our witness list. Yes.
Right, okay. But I mean, anything else by Ms. Tope that was...
I filed my witness list, and then she filed her witness list hours after. But to my knowledge, Ms. Tope is still representing the wards in the circuit court action. And it seems like they are still having communication in this case.
The communication I don't necessarily have a problem with, because I don't know that I could stop that in any event. What I do have a problem with, when things are filed before this court, presumably on your behalf, but without your knowledge. And then counsel has to spend time looking at it and trying to respond to something that you guys didn't file. And you don't even know what it is at this point. Have you seen what was filed in court on your behalf?
No.
She then interjects herself, and quite frankly, interjects herself in a way for anybody to do it is a bit appalling. For an attorney to do it is tenfold that. If Ms. Tope were representing you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. But she's now filed something, not as the attorney, on your behalf, and you have no idea what it is. After some consultation as to some of the ethics that have been involved, I'm going to set an order to show cause for Donna Tope to show cause why she should not be held in contempt for the filing of this. I would just place Ms. Ward, I would place you on notice that you have made a specific representation to this court that you had no knowledge of any of that. And so I'm holding to that representation in terms of setting this notice or setting this order to show cause. Counsel for the plaintiff, in the event that the court would award sanctions and or costs, I would need a billing from you and laying out from certainly the time Friday, time that you received this, what you had to put in to do that. I will then adjourn it for the motions and for the order to show cause to February 3rd.
Can I hear again what those two purposes are?
One are the motions that I'd like to rule on at some point, but the other is for an order to show cause as to why Ms. Tope should not be held in contempt of court and or sanctioned.
On that second note, does that have anything to do with me and...
Oh, it certainly does. Here's going to be part of your problem, as it may be. I will have to make a determination if Ms. Tope gets here and says that was filed with your full knowledge and authority because you have represented to the contrary. And so I would suspect that when the two of you get here, you are going to be very much at odds.
So you're going to reach out to her separately, though I don't have...
Oh, no, yeah, we will be sending a little piece of paper commanding her to be here.
I quote from their circuit court complaint, this is paragraph 2. Erica Ward leases the property to conduct her business. Erica's business is an equine boarding and training facility. This court, again, acknowledged the commercial nature of this lease dispute. Tenants argue that the lease does not use the word commercial. It does not use the word residential. It is a 7-year lease ending April 2028. In the circuit court, tenants individually are bringing a business interruption / tortious interference claim against landlord, seeking alleged lost profit damages. So tenants are seeking alleged damages to their business on the property under the lease in the circuit court, while conversely arguing that the lease is residential in this court.
Your Honor, actually, that is not the case. For the past 2 weeks, based on review, we fully understand that the lease has been deemed a commercial lease, and that under a commercial lease, you cannot withhold rent. However, we believe our motion for dismissal with prejudice should be heard, and that their entire basis for their summary disposition or the request for summary disposition is based off of a retaliatory eviction based on the law and the research that I've gone out and done on my own since I dismissed my lawyer, or she withheld, whatever you call it.
Any reason you believe I should not grant their motion for summary disposition as to liability?
So I didn't know what else to do when this landlord is refusing to do anything, to repair anything.
And what I'm indicating to you is I don't think you can do that. As to the issue of rent and viability for breach of the lease, but not as to damages and remedy, I'm going to grant the motion for summary disposition. As to the amount of damages and as to the remedy to be applied as being a summary proceeding, the court will make a later determination on that. Now, in regard to that show cause, I issued an order to show cause to Ms. Tope. That was on January 20th. Show cause was sent out. 14 days was given. As best I could see from the file, it was certainly sent out. It was sent down to the clerk's office and mailed out. We then get a email from Ms. Tope, and it's entitled 2 p.m. show cause today. It's addressed to my judicial coordinator. And it says, hello, I have not gotten any notice at my address or email for the show cause D. Tope. You show scheduled for today at 2 p.m. on Judge Simpson's docket. I do not know anything about this. I have not had any contract from the court about it, and am unable to attend. For Ms. Tope to say that she had no notice of it or anything along those lines is just patently false, because I have the emails of those various dates, the 27th, the 30th, and the 2nd, where Ms. Tope is emailed directly at her email address showing this to be scheduled. So it is once again a delay on her part to not show up. I will go further to say that she consistently flaunts this court's orders by, when she's off of a case, filing documents. But her behavior to this court is, for a member of the bar, is atrocious. And what I think, at least as I've seen in 2 cases, predicaments which she has put individuals which she alleged to have or was representing, is also, from my perspective anyway, atrocious and highly unethical in terms of some of the ways that she's been proceeding. So it is with great dismay, but when an attorney or someone tells me I'm not appearing, I know they've had notice of it and they refuse to come before the court. The court is only left with one other option, which is its ultimate way in which to compel someone to appear. And so I'm going to issue a bench warrant for Ms. Tope's arrest. What's the approximate amount that you have at this point?
Your Honor, that I have at this point is $6,975.
Enough. So I will issue a bench warrant. Bond will be set in the amount of $10,000 cash and or surety. That warrant will issue immediately. Did you receive from Ms. Tope a motion to remove and expunge the court's order?
Got an email copy of it that I'm aware of, yes.
Okay, so
I don't know the result of it, though.
I can tell you part of the result of it is that she marked it an emergency. I did not deem it an emergency. So I set it for hearing today along with the other motions. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion, Donna Tope's motion, will be adjourned. And I'm not changing anything. The bench warrant is still outstanding.
He evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on.
This is going to be a disaster.
A total outstanding $48,691.04. $26,125 of that is accounted for in the court's escrow account. And the other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so,
Can I just stop you there? I don't think that the monies you paid were properly put into a trust account with Ms. Tope. That causes huge problems, which I don't know what I'm going to do with entirely. Have you asked her for the money back?
No, they're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So, okay, no, I'm never going to get my money back.
Here's the problem. What really should happen in this case, and if Ms. Tope were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on it, if she did that improperly out of an IOTA account, she should then pay that money to plaintiff. You guys wouldn't have to pay more. That's not going to happen, I don't think. She may have told you those were legitimate expenses. They weren't legitimate expenses. My problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. This is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees haven't been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, counsel. That's where I may land. But I want to just think about that for a moment. I, quite frankly, have never been through anything like this before either. Your client's out, your fees, plus he hasn't gotten the rental income. These folks, they're out at least what that difference is because they paid it over. And now, because of all of that, he's in foreclosure. You're not in business. It's a beautiful scenario and shouldn't be how things should work. Over my 26 years, I'm not sure I've seen one person cause this much damage. I am going to award judgment to the plaintiff, the monetary part in the amount of $48,691.40. I am going to order that the $26,125 is to be paid to the plaintiff. The resulting balance, I'm going to indicate that no collection proceedings regarding that amount can begin against the wards until May 31st. I'm picking that date to give them time to figure out if they have other remedies regarding that balance, and give them time to sort that out. Should they seek to get counsel? Should they seek to go to the bar? Whatever they may wish to do. So I'm giving that time frame. As I think I had indicated from the very beginning of this case, you may have claims as against Ms. Tope.
Okay.
That can come in various forms. And so I'm not suggesting one or the other. I'm just giving you an opportunity to explore your options as to how you remedy this. Because here's the cold-hearted reality. You're going to be out an additional whatever amount unless somebody makes that up. But counsel's right. It's not the plaintiff's obligation to do that. It's going to be whatever you decide to explore there.
Donna Tope, I'm appearing on behalf of myself.
Ms. Tope, I had issued a bench warrant for your arrest for failure to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt and the warrant for your arrest. That is your motion before the court today. Go ahead.
I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and or other cases, and therefore I would like to have this on the record.
Of what on the record?
What I'm going to tell you now in my defense. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling. I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time, so I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I checked my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Weedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box 2 days after the hearing was held. The photos included with my email to the court are of a motion, affidavit, and order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th, the date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed, which is 6 days shy of the required 14-day notice by mail. The facts are that I was not properly served nor properly noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that I made that day that you had notice of that hearing and that you failed to appear. My staff indicated that. You can argue with me all you want, Ms. Tope. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading. You signed it. Your former client had no knowledge of it.
That is not,
it was delayed.
Not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. Amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14, 2026, 9 a.m. Thank you. Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Thank you. Fixing housing versus Erica and Aaron Ward in regard to the matter of the show cause of Donna Tope. State your name, please.
I, Donna Tope, sworn by myself, come before this court to say that there is no basis for holding me in contempt of court.
Tope, I'm going to cut you short.
Okay.
I'm going to just indicate that I read your response. While I don't necessarily agree with what's in there, I don't think it's going to be incumbent upon the court or upon you to go ahead with the show cause at this juncture. The case has been dismissed. It's over. My understanding is that there was regrettably a foreclosure. The horses are now elsewhere. And so I'm no longer going to proceed. I'm going to dismiss the show cause without prejudice. So it could come back, but it's unlikely. Thank you.
Thank you.
I'll go back.
All right.
He's not.
14A stands in recess.